Have you really? Yeah. Holy crap. We're good? Okay, this is called the meeting of the Tennessee Auctioneers Commission, May the 5th, 2014 to order. If you would you call the roll, Miss Susan?
Bobby Colson.
Here.
Ronnie Collier.
Here.
Gary Cunningham. Jeff Morris.
Here.
Howard Phillips.
Here.
You have a quorum, Chairman.
We have a quorum. First item on the agenda is a formal hearing, and we're going to turn it over to council to start.
All right, thank you, Mr. Chairman. Let's go ahead and start our contested case hearing then. Today is May 5th, 2014. We're present in Nashville, Tennessee for a hearing for the Tennessee Auctioneers Board. The board is meeting today to consider the case of Kent Calvin Ward and Crow's Nest Auction House, docket number 12.32-125-153A. My name is Steve Darnell. I'm an administrative law judge assigned by the Tennessee Department of State Administrative Procedures Division. I've been designated to preside at this hearing today. As such, I'll make all rulings regarding the order, proceedings, admissibility of evidence, and procedural questions of law pursuant to the authority granted to me by the Tennessee Administrative Procedures Act. In other words, it's my duty to conduct the hearing and regulate the course of the hearing and rule on any evidentiary procedural legal issues that arise during the hearing. I will not participate in the findings of fact or the ultimate decision by the board. Those decisions are reserved to the board members only. At this time, go back to, well, I know we just did this, but members of the board, would you introduce yourself on the record? Let's start at the far end here.
Ronnie Collier.
I'm Jeff Morris.
Bobby Colson.
Howard Phillips.
All right. And our board is chaired by Mr. Morris, is that correct?
Correct.
All right. Mr. Morris, this constitutes a quorum of this board.
It does.
All right. Counsel for the state, would you introduce yourself to the board?
My name is Robin Ryan.
Excuse me just one second. We're going to have to get you on a microphone somewhere so we can get this on. Well, we can hear you fine. The recorder can't hear you.
Thank you, Ms. Ryan. Who is your party representative today?
It'll be Kimberly Waiter.
All right. Is anyone present on behalf of Kent Calvin Ward or Crow's Nest Auction House? All right. Let the record reflect no one's presented today to represent either of those parties or that party, and it is about 10 minutes after 9. All right, members of the board are reminded that during the time the hearing is being conducted, there's to be no discussion concerning the case between members of the board and myself or witnesses, attorney, or anyone else, unless all parties are present. During the hearing, the board sits as a jury, must only consider the evidence introduced in the hearing in reaching its decision. The Sunshine Law requires that all board discussions be in public before all parties. Board members, you're reminded that law requires you to disclose on the record any outside knowledge you may have of this case. Does any member of the board have knowledge of this matter? All right, let the record reflect that the board members are indicating no. All right, Ms. Ryan, no one has appeared on behalf of the respondent. What's the state's position on that?
Your Honor, we attempted to serve Kent Ward and Crow's Nest at very all mail attempts for the state-provided addresses have come back unclaimed or unable to forward. We've also made several phone calls as well and have emailed it to the last email address we have had from him. I would like to put proof on the record, Your Honor, concerning those attempts we made beyond this certified mail and asked we call Jenica Smith to the stand.
Right. Let's see, where do we want to put her here?
Over there be fine. Wherever she can get a microphone that's hot.
All right, ma'am, if you'll have a seat there and then raise your right hand, I'll place you under oath. Do you solemnly swear or affirm to tell the truth and nothing but the truth, so help you God?
Yes, sir.
All right.
Would you please state your full name for the record
My name is Jenica Smith.
and your position with the state of Tennessee?
I'm a paralegal for the regulatory boards.
And are you a paralegal for the Auctioneer Board in particular?
Yes, ma'am.
And as a paralegal for Auctioneers, are you familiar with the Kent, Calvin, Ward, and Crow's Neck auction files?
Yes, ma'am.
Have you called either Mr. Ward or Crow's Nest?
Yes, I have used 4 phone numbers for him.
And where did you get those phone numbers?
Within the file and different internet searches for Crow's Nest.
And can you read into the record the numbers you attempted?
Sure. Area code 910-755-2465, 910-755-2965, 910-269-6851, 423-787-1028.
And did you leave a message at any of these places?
The first 3 phone numbers were disconnected. I did leave a message for the 423-787-1028 phone
And
number.
did you have a return phone call?
I did not.
And did you also attempt to serve at other physical addresses as well?
Yes, we tried the 291 Southwood Road, Whiteville, North Carolina.
Is that the address he has with the state of Tennessee?
Yes.
Thank you.
We also tried 172 East 2nd Street, Ocean Isle Beach, North Carolina.
And were you successful with either of those addresses? No. Did you try any more physical addresses?
Yes, we tried 4606 Main Street, South Brunswick, North Carolina.
And any others?
310 Gray Bridge Road, Charlotte, North Carolina.
Has mail been returned from either of those addresses?
No.
But they were returned from the previous 2 addresses? Did you also attempt to email Mr. Ward?
Yes, I tried 2 email addresses.
And where did you get the email addresses?
From the file and with the North Carolina Auction Commission.
And what results did you have with the email addresses?
The auctioneer Kent at yahoo.com was returned undeliverable, and the Kent Crow 355 at yahoo.com just did not receive a response.
So you've not heard anything, even though you've not received any notice that that email address is no longer valid?
That is correct.
Okay. Have you contacted any other state concerning Mr. Ward's license?
Yes, I contacted North Carolina Auction Commission.
Is that where you got some of the additional addresses?
They had all information that I already had in the file.
Okay, and nothing new?
Nothing new.
Okay. And where else did you look for addresses besides what you got from our files and besides what you got from North Carolina?
I did internet research along with you.
Okay. And that's where you found the additional 2 addresses, is that right?
Yes,
And those are the addresses that you sent mail and have not been returned?
that is correct.
Your Honor, I ask that we be granted a default judgment because we would assert that Mr. Ward and Crow's Neck auction have been served, or all attempts have been made to be served. Mail has come back unclaimed in the first instance, and the other instances, they have not come back at all. And ask to be allowed to proceed on default.
All right, thank you, Ms. Ryan. Members of the board, I find that the state has made good service and/or all reasonable attempts to give this party notice of today's proceeding. As you are aware, he's to provide and keep his address with the commission updated and has failed to do that. Apparently, we don't know if those were returned or not. So I'll turn the matter over to the board to vote on whether to grant a default or not, or you can adjourn the case and require the state to make further efforts. If you decide to hold the gentleman in default, then you have to decide whether you want to adjourn the proceedings or let the state proceed uncontested. Ms. Ryan, I'm assuming that's what you want to do?
Yes, Your Honor.
All right. So I'll turn that back over to the board.
Be glad to do that. Do we get to have knowledge of what the charges are against this case?
Certainly, if you hold Mr. Ward in default, then we'll proceed, and you decide to proceed uncontested, then Ms. Ryan will present her case. And
Perfect.
you'll hear all that.
Well, at this time, the chair would hear a motion from the board as to accept the default position of the state. Anybody make a motion to that extent?
I don't know the correct words, so I'm going to make a motion. I make a motion that we dismiss this forever and don't spend any more money trying to collect somebody that it's going to be impossible to ever get to Nashville, Tennessee.
Unfortunately, it's either default or not default. They either got to put on the case or not put on the case. That's the only choices we have at this time, Howard.
I make a motion that we don't put on the case.
Been made. Anybody want to second that?
I'll second it.
Okay, it's been made and seconded. All those in favor say aye.
Let me make sure I understand. So when the motions did not to put on the state, are you motioning that the state just dismiss its case and not take any action against this gentleman?
Your Honor, I don't believe we can do that.
I don't think so either,
Well, that has to be carried, but is that your
but
motion?
that's his motion.
All right, and that was seconded by Mr. Colson?
Yes, it's seconded.
All right.
Board like to vote? Go ahead and vote. All in favor say aye.
Aye.
All against? I guess there's three in favor and there's one against for that position. I don't know where that puts you, Judge.
Well, may I explain?
Yes.
a little bit? We cannot dismiss the case. The matter will stay active. It is a very serious matter, I will tell you. We've already voted, but it was a very serious matter of taking money not belonging to him. He can, and his license is active, and it remains active to September, after which he has 2 years to renew. So he will be practicing again. Thank you.
All right. Well, the board's vote was to dismiss the state's action, and that carried by a majority or of the quorum that's here. So the contested case matter will be dismissed.
But the actions against internally will not.
Well, that's, the contested case proceeding at the Administrative Procedures Division will be dismissed. So, Ms. Ryan, will you submit a short order to that effect?
Indeed.
All right, thank you. Any further business for the board before we adjourn our contested case?
Guess not.
All right, thank you, gentlemen.
Thank you, sir.
Yeah, I'm going to call a quick recess. Yeah.
Your Honor, I am going to go get our chief counsels. If you don't mind waiting a minute so that we understand procedurally, put on the record procedurally where we are at this point. Just
Well-
because I do think I have to have them aware.
I'll be glad to stay around, but the board's business on the contested case matter
I know,
is,
but, okay, I
has
just want to
been
put that on the record.
resolved.
That's fine. Thank you.
all right. All right, gentlemen, so we're adjourned at this point?
We don't care.
We're going to resume our session. This is May the 5th, 2014. We've passed the formal hearing portion of our meeting, and now we're going to our regular meeting, which will begin now. If we would call the roll once again.
Bobby Colson,
Here.
Ronnie Collier,
Here.
Gary Cunningham, Jeff Morris,
Here?
Howard Phillips. You have a quorum, Chairman.
Okay, good deal. We've had the roll call. Would you please read the notice of meeting, please?
This meeting's date, time, and location have been noticed on the Tennessee Auctioneer Commission's website, included as part of this year's meeting calendar since August 16th, 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Auctioneer Commission's website since April 30th, 2014. This meeting has also been noticed on tn.gov's website.
Thank you very much. So we've had our notice. We have our agenda in front of us, gentlemen. We'll take a look at that, and let's approve that agenda for today's meeting.
May I make one comment before y'all do that? There's a strikeout under my legal report about some update regarding the rules that says deferred. I did hear back from the AG's office, and I would like to discuss that with you all, if that's all right with you
All right,
today.
we'll put that back on the agenda.
I move we approve the agenda.
Second.
Been moved and second. All in favor say aye. 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 The agenda has been approved. If you would review the minutes fairly quickly, I think y'all have done that. And Chair will hear a motion to approve those.
I move we approve the minutes.
Moved and seconded. All in favor say aye.
Aye.
Minutes have been approved and adopted for our last meeting. Wendell Hanson, would you please give us an educator provider update?
I have none this week.
He has none. Okay.
Last meeting.
No, perfect. It was just on the agenda. Had to call it out. Glad you're here. Judy, you want to go and do your legal report?
Right. Well, can you hear me? Is that picking up?
Yes, it
Okay,
is.
good. All
We're
right.
under
It's
tab 2, gentlemen. if you
It's a
want to
little
pull it
far
up.
away, but I think it's grabbing it.
Yeah, look, I have.
Okay, The first 5 matters I'm going to read because we reread everything into the record, but it's just being represented with regard to one, and I'll answer any questions at the end. The matters are 2012-011-211, 2012-012-401, 2012-012-402, 2012-025-891, and 2012-025-901. These were originally presented at the August 2012 meeting. It was a tack open complaint based on a copy of a newspaper advertisement received, which advertises an auction of antiques, furniture, home decor, etc., which lists the name of an unlicensed entity, which is Respondent 1, based on information in the newspaper advertisement referencing an auction zip ad, which contained the license number of Respondent 2, auctioneer, and the name of Respondent 3, auction firm. Complaints were opened against these 3 respondents. Response was received stating that Respondent 3 was unaware that Respondent 1, a separate business, needed a separate license since Respondent 1 mostly auctioned its own property. Respondent 3 states that Respondent 1 has ceased any consignment auctions until the complaint is resolved and they are instructed on how to comply. Regarding the newspaper advertisement's lack of including the firm name and license number of Respondent 3 states that this was an inadvertent error on the part of the newspaper, which has been addressed, and a letter from the newspaper was included confirming this. A telephone call with the owner of Respondent 3 firm confirmed that Respondent 1 is a separate business owned by one of Respondent 3's apprentice auctioneers. The apprentice has closed Respondent 1 business and plans to obtain a gallery license before engaging in activity of this kind in the future. The recommendation was, as to Respondent 1, a letter of warning regarding Tennessee Code annotated Section 6219-125's gallery license requirement. As to Respondent 2 and 3, a letter of warning regarding Rule 0160-01-.20 Subsection 1's requirement that auction advertisements must contain the name and license number of the auction firm or gallery responsible for holding the sale. The decision was that the Commission voted to defer the matter in order to send it out for investigation to determine how many auctions Respondent 1 did and whether Respondent 2 properly sponsored all auctions. The matter was represented in December 2012. An investigator was sent to obtain additional information regarding this matter. The investigator's report includes that the investigator spoke with and obtained an affidavit from the owner of Respondent 3 firm, who stated that an apprentice auctioneer with the firm owned Respondent 1. The owner stated that Respondent 1 held approximately 8 auctions consisting of household goods, furniture, and antiques. Respondent 2, the principal auctioneer for Respondent 1 firm, was present and supervised at all auctions. Further, the owner of Respondent 3 stated that Respondent 1 has held no additional auctions after being notified of this complaint. The investigator also interviewed the apprentice owner of Respondent 1 and requested copies of listings of items sold, bid sheets, and invoices from the 8 auctions held by Respondent 1. According to the investigator, the apprentice owner of Respondent 1 promised to provide copies of the documents which were in storage. The investigator made multiple unsuccessful attempts to obtain the documentation. The new recommendation was to discuss, and the Commission voted to open complaints against the apprentice auctioneer who owned and operated unlicensed Respondent 1 and the apprentice auctioneer who is the owner of Respondent 3, and handle all of the complaints together at an upcoming meeting. February 2013 meeting, pursuant to the direction of the Commission, complaints were opened against Respondent 4, the apprentice auctioneer who is the owner-operator of Respondent 1 unlicensed entity, and Respondent 5, the apprentice auctioneer who is the owner of Respondent 3 licensed firm. Respondent 4 and 5 submitted responses to the complaint stating that respondents were unaware that Respondent 4 needed a gallery license for Respondent 1 entity because Respondent 4 was selling over 60% of Respondent 4's personal property. Respondents state that all auctions for Respondent 1 unlicensed entity have ceased until the complaint is resolved and they are instructed on how to comply. No information has been received to indicate that the unlicensed entity is engaged in any auction since the time the complaint was filed. The new recommendation was to close as to Respondents 3 and 5, as to Respondent 1 a letter of warning regarding license requirement of 6219-102, and as to Respondents 2 and 4 letters of warning to each regarding Section 6219-125's gallery license provisions. The decision was that the Commission voted to authorize a consent order for Respondent 2 and a consent order for Respondent 4, including a civil penalty of $500 for each respondent for operation of unlicensed gallery in violation of Section 6219-125 and 6219-112B7, and closes to Respondents 1, 3, and 5. The matter is only being represented as to Respondent 2. Respondent 4 signed and satisfied the consent order outlined above. Recently, new information was yielded that Respondent 2 is facing serious health problems, is in full care in a nursing home, and is unlikely to return to auctioneering as a result. In light of this new information, closure is recommended as to Respondent 2. The new recommendation is to close. I'd be happy to answer any questions. I realize that was a complicated series of facts. That's why I included the entire background, hopefully give you as much of an idea as possible.
Remember that case?
The person who is in the nursing home was what?
The person that's in the nursing home is respondent to the person that was the sponsor of the apprentice.
He was the auctioneer.
He was the auctioneer who was the sponsor of the apprentice that was operating this unlicensed gallery. One of the individuals, it was either the apprentice or the owner of the other entity, said during the investigation that he sponsored the auctions. I'm not sure. That's the information that they had gotten. That's the person who's facing these serious health issues at this time. The other individual, the apprentice, signed and paid the consent order that was authorized by the commission. So that's how that matter was closed.
Information come from that he's in the nursing home and in bad health?
My paralegal Jenica, who just spoke during the formal hearing, was assisting Ms. Ryan in getting this matter prepared for a formal hearing, and they contacted, I believe, the respondent's wife. Back when this consent order was originally sent, I was contacted by this individual myself, who was in the hospital at that time. I spoke to the person actually from the hospital telephone, the hotel, the hospital room. So I know that there were some health problems at that time. I believe it was the wife, am I correct, that said that this person is in long-term care facing serious health issues at this time. And if for any reason, the recommendation is to close this. If for any reason in the future we find that this person's back in business and there are problems of any kind and there's information received that necessitated a reason to reopen this, I believe that's something that we could do. It's just in light of these circumstances, that's the recommendation.
I move we go with legal's recommendation.
Second.
Been moved and seconded. All in favor say aye.
Aye.
Aye. Motion carries.
2014-005031. Complainant states that respondent, firm, advertised an engine utilizing information which corresponded with a 1989 build. However, complainant states that when the engine was picked up, there were actually two identification plates. One plate utilizing the information used by respondent to advertise the engine, and the other plate for another model. Complainant states that the identification number, which was actually stamped on the engine block, corresponds with a 1982 build instead of the 1989 build, which was advertised by respondent. Complainant provided documentation including an invoice copy showing the lot number, purchase price, and serial number of the 1989 model, as well as an email from the online auction where the engine was purchased with a link to the website page showing the final bid, respondent's information as seller, the condition labeled used, the serial number, and states that it fits a 1989 model, as well as several pictures, one of which appears to have a zoomed-in picture of an identification plate featuring information for a 1989 model. The terms and conditions on the website do state in part that all equipment is advertised to the best of our knowledge and everything is sold as is with no guarantees. Complainant states that complainant's father spoke with one of respondent's representatives when picking the engine up, who offered to relist the engine on the auction site for complainant, but complainant states was unclear in stating how the engine would be advertised. Complainant states that complainant had a buyer for the engine model advertised, but the buyer was not interested in the actual model. Respondent submitted no response to the complaint. It appears that the information advertised regarding the motor, including the fact that it states the serial number and that it fits a 1989 model, constitutes false, deceptive, misleading, or untruthful advertising. Further, it appears that based on the information provided, this was a rebuilt motor which had several plates showing at least two different models. The fact that the engine was rebuilt does not appear to have been disclosed, but merely it was listed as used, which appears to constitute a substantial misrepresentation. The recommendation is authorize a formal hearing with authorization to settle by a consent order with a civil penalty of $1,000 for a violation of Tennessee Code Annotated Section 62-19-112B1, making any substantial misrepresentation, and 62-19-112B7 and Rule 0160-01-.20 subsection 2, prohibiting false, deceptive, misleading, and untruthful advertising.
Question from the board?
So the plate, with the identification number on it, was advertising?
There were a number, 6 or 7 photographs in the online advertisement, one of which, so most of them were from a distance of the entire item, and so I don't know if there were multiple plates shown in there. I could not see details on any of them except on one photo.
There was one where you could read the.
One where the whole photo was of the plate, it appears, and I'm by no means an
Right,
expert on motors, but it appears to be a plate because I can see where it's screwed on.
Right.
It's got a lot of information on there. It has, among that though, the year number, and it does say 1989, which this complainant says was not stamped on the engine block, and apparently the complainant's father, when picking it up, noticed that immediately.
Which actually an 82.
It looks like maybe it was,
rebuilt.
I mean, correct me if I'm wrong, but it appears that it might have been rebuilt since there's plates for both, but it's stamped on the block that it's an 82 model. I could be misunderstanding. That was my understanding of the information.
Did the auction company offer to give the guy his money back?
They offered, according to the complainant, that when he went to load the engine, he was told to talk to a specific person who was not there at the time, left multiple voicemail messages while was there, stayed in a hotel overnight hoping to meet with the person the next day. They did talk by phone the next day, but nothing was resolved. Apparently the individual did offer to relist the engine on the auction site for them. The father did ask the individual if they were going to list it as the true model that it was or the model that it was advertised for, because apparently the model that it truly was, they said, would never bring the price of what it was advertised for. And they said that they didn't give a straight answer. So because he says it wasn't resolved, I don't think that ended up happening. So it says was never resolved.
My mistake.
You all are more familiar with it than I am. I tried to get as much information as I could from this individual.
Was this just an online auction?
It was, it appears to have been, because I received the attachment from Auction Time, which is, I believe.
Are they in-state or out-of-state?
This person's located in state, and they did sign for the complaint. They just didn't submit a response.
They have a Tennessee auctioneer license.
They got a firm license.
Firm license. It's open against the firm.
It's a Tennessee firm that did an online auction
Yes, sir.
of this engine.
It appears to have been online only, because it was, I mean, I'm seeing the bid amount. It's stamped when it closed, you know,
Okay,
the winning
okay.
bid. Because I was actually forwarded the website from where it has the pictures and
So the
things.
guy went to go complain about it, and they wouldn't really talk to him. They didn't offer him to give him his money back, but they did offer to relist it or resell the item.
Correct, but apparently we're not clear as to
Right.
how they were going to advertise it. So the inclination I left with them, between them saying that it was not resolved and this person having this motor that he now says he can't sell, the buyer's no longer interested in it. I take it.
Did
that
the complainant state that they had any opportunity to inspect the property prior to bidding on it?
They did not state that. This individual, I am not sure where the complainant is. The complainant is also from Tennessee, I believe. But no, I did not ask him that. I'd be happy to get that information if that makes a difference. I don't see where anything says, I mean, under the terms and conditions, it says you can call a number, and
But even an online auction, a lot of times the auctioneer will provide an inspection time for you to come by and look at the items that you're
Right.
selling.
I'm just not positive. The information I have doesn't specifically say one way or the other. I just have the paperwork and then what was included in the complaint and then my subsequent follow-up conversations with
It
the.
sounds like that he offered to resell the engine for the buyer,
Correct.
That's right.
and the buyer would go ahead and pay for it, and then the auction company would resell it for him.
And I assume maybe recruit some, if not, depending on what it's sold for. I would imagine that would be how that would go, but.
I am ready for a motion.
Make a motion that we take legal's recommendation.
It's been moved to accept legal recommendations. Is there a second?
I'll second.
Been seconded by Mr. Collier. All in favor, say aye.
Aye.
Aye. Motion passes.
Those are the only two matters I have on there. I did have a note from Miss Ryan to turn it over to her regarding how to handle from our side, the matters that we
Ms.
just
Ryan,
disposed of.
please proceed.
Thank you. This is going to represent the underlying complaints in this matter that you heard earlier today. Complaint number 2013-020511. In this particular matter, the allegations are as follows. On or about June 16, 2013, the complainant and respondent executed a consignment form wherein respondent's firm agreed to hold a consignment sale of household contents belonging to the complainant. The respondent spoke with the complainant by telephone and gave varying accounts on how much of the property was able to sell. Despite assurances to the complainant, the respondent has failed to provide complaint with itemized statement of items sold or any payment for the same. In complaint number 2013-00931 and 0133531, in this particular matter, on or about March 20th, 2013, complainant and respondent entered into a contract for auction of personal property to be held on April 5th, 2013. On or about April 5th, the auction of complainant's property was held, and a family member was the winning bidder of multiple items, including but not limited to a diamond ring and a tray of gemstones. There was a $750 reserve on that diamond ring. The family member did not pay for the items at the auction. During a police investigation, the respondent admitted that the items were won by a family member and were resold for approximately $600 at a subsequent auction, and that the ring was originally sold at a reserve price of $750 and later sold for $300. The respondent told the detective that they would have to pay the complainant the difference in the amounts. The respondent did not pay the complainant the difference between the amounts sold and the amounts that actually sold at a later auction. And in complaint number 2013-13531, in that particular matter, that on or about April 19, 2013, the complainant respondent entered in an agreement wherein respondent's firm agreed to auction contents belonging to complainant. According to a settlement agreement provided by respondent to the complainant, the items sold a net price of $2,316. Respondent has failed to give any of these monies to the complainant. In response to some of these, in the one concerning the jewelry, the respondent stated that they paid a check to the complainant, and she was sent a final statement but did not sign it, but cashed the check for $139, and therefore it is agreed and final. And in the other one, the respondent to the most recent one said that you will receive your money owed in 45 to 60 days or sooner. None of the money has been returned. In one of the cases, you had originally asked for a civil penalty. Voluntary surrender in all three of them?
I believe it was for all.
Voluntary surrender in all three of them, and no money settlement, Doc?
No, I think it was just all.
Surrender of their license, is it? Okay.
But of course, they didn't do that or sign a consent order, so this remains active. These parties' license remain active until September of this year, and then will remain active for another 2 years.
What about the email that he sent to me?
And I will tell you that there was an email, further correspondence to Ms. Kropp, wherein an email to her said,
I don't have it in front of me. Essentially, when I'd asked for some additional information on a couple of the complaints, this is before the consent order was sent, the person basically said all files were destroyed in a flood. The first complainant regarding the ring was paid the money and cashed it, and it stated paid in full. The board doesn't govern what we charge on commission, so there's no explanation for what that. She has cashed her check. There's no contract that this person had for the complainant who had the household contents that were sold. It said that this person was back in North Carolina, so let the board do whatever they need to do. The person says they're through with the auction. The firm is closing, and the money for one individual was mailed to a bank. So no more on the matter. And the phone number I had was no longer good. The firm is closed back in North Carolina. So that was the last,
right, this
last
person
correspondence I had.
had a license here in Tennessee and a license in North Carolina. He was here by reciprocity. He lives right on the border. And we have no proof that he's
We
not.
don't have his North Carolina license anymore?
He has a North Carolina license.
But I'm talking about right now.
And he just, in that particular case, he asked to be put in inactive status. But he's done nothing to address the issues here in Tennessee. So it's up to you all to make the decision. It's based on your earlier thing. What you would probably have to do is dismiss everything. Just understand that we dismiss it, it remains active for another 2 years.
If you don't have a North Carolina license, how can he reciprocate? If it's
He
North
had it in the
Carolina
first
license?
place.
That's how he
Got
got
his
his
license.
license.
Yeah, but what you
No, I'm talking
have.
about now.
Yeah, but you don't have to maintain it.
You don't have to maintain it.
You don't have to maintain
No.
a license the states you're reciprocating from?
No.
That's a bad law.
You're no kidding. But no, you don't have to. Once you get it, you got it.
It don't have to be in good standing
No,
in the license you're
No.
reciprocating.
As long as they continue with their continuing education here and things
No.
of that
That's
nature.
just,
That's a
I know.
bad law.
I understand, but that's the law. We're not lawmakers, we're just rule makers.
You mean, I have a Kentucky license and a other license and
Mr. Phillips, your mic. Thank you, sir.
on,
Thank you.
and I don't have to do that continuing education and all that stuff they send me now?
I don't know
Do
what
in
Kentucky
Tennessee.
law
You'll have to
is.
then meet your
But-
Tennessee requirement.
But you have to do the same thing in North Carolina, right?
we-
You've got to keep up your continuing education.
For that license, I would assume that, I don't know their particular
We
requirements.
have a gentleman sitting behind you that does know the answer to that question.
Let me explain how the licensing works.
If you'd like to say something, Mr. Dickinson,
Do you want me to say something?
if you,
Do you know the answer to that question? That's my question.
Yes, I do.
Okay, I would like for you to say something.
Do I need to do anything? Oh, here it is.
Oh.
You have to maintain a North Carolina license, you have to keep your continuing education, or in your case, you said Kentucky license, yes. But you don't have to keep your Tennessee license active in order to keep your Kentucky or North Carolina license.
And vice versa.
But they came from North Carolina to Tennessee, right?
Once
You
you,
could drop
one-
your
one-
Tennessee license and still have one in Kentucky reciprocating, even if a Tennessee license wasn't in good standing. It goes both ways.
Well, not in good standing. If it's not in good standing, then that would affect your other license.
That's
But
what
if-
that's what I was saying. If he's not in good standing in North
He
Carolina.
is
Well,
in good
not-
standing.
but he is, he's just
He is-
inactive.
He is in good standing. in
He's
North
just
Carolina.
inactive.
Oh, okay, I misunderstood then.
He's
Yeah,
inactive.
He made it inactive.
Oh, he made it inactive in North Carolina.
Yeah,
That's
but
correct.
you
Yes,
don't,
sir.
you don't have to have an active license to maintain a Tennessee
Okay,
license.
I thought it was he hadn't paid it or something. Okay, well, that makes sense.
Any other questions from the board? Anybody care to make a motion
On what?
on this case?
I thought we'd already made a motion on this case.
No, we had,
we did
no,
on that
this is,
hearing.
the- on a hearing, this is
Representing-
this is the complaint, Howard.
The
your,
representing the
your
complaint.
motion in the hearing was to how to dispose of the administrative law case. It had a separate docket number. Once it's filed with the Administrative Procedures Division, it receives its own docket number. That one began with a 12 that he read out at the beginning. Your motion was to dismiss the administrative
The hearing
hearing,
portion of
but
it.
it leaves behind our complaints, if that makes sense. Does that better explain? Okay.
In one of those complaints, did I hear you say when they were talking about a ring or something that the seller's brother bought it or something at the online auction or something?
It wasn't online, it was in person, and the answer is yes.
The seller's brother, okay.
I think it was a
A cousin.
family member.
Yeah.
It was
Family
a family
member didn't
member.
say
A
what.
family member, okay. Was it an estate or something, or,
No,
no? Okay.
Is there something wrong with a family member buying a ring at an auction that belongs to somebody
oh,
cousin?
no, but she didn't pay for it.
Oh, okay, well, there's something wrong with that.
Any other questions?
I move that we revoke his license.
You can't do that without a hearing.
Oh, okay.
We can issue a penalty,
You can issue a penalty, that's correct.
and what's the maximum penalty for
It's
this?
$1,000 per occurrence, is that right,
And if he
Julie?
don't pay the fine, his
But he's
license
not,
is
if he
inactive.
doesn't pay it, then we'll be back at a notice of hearing and charges
Right,
again.
right.
So what I'm asking is, because you dismissed the notice of hearing today, and we have this underlying complaint, I'm asking you to dismiss the entire thing. Because I can't go forward with a hearing without everything being in place.
The legal's recommendation is to dismiss this
As you
complaint.
dismiss the notice of hearing and
Right.
charges, yes, my assumption was in dismissing that you felt to dismiss the entire matter, and so I'm just cleaning it up.
There
To
you go.
dismiss the entire matter.
Chair will entertain a motion.
Did I hear you say that you can make a motion to give him a civil penalty of X number of dollars, and if he doesn't pay that, you can have a hearing before the board? And
Which is what we've done already.
And if he
Just did
doesn't
that.
show up, then,
It's exactly
Is it-
what would happen today again. He's not gonna show up.
right.
So, my understanding, and Mr. Phillips, and I'm not trying to be difficult here, but one of the comments was made is that there was no sense wasting time and money, and I'm just trying to clean this up. You dismiss the notice of hearing and charges, Now I'm asking you to dismiss the complaint so that we don't pursue it further.
And I stick by my statement that there's enough money been wasted and nobody's sitting out here in the chair to testify. I can't believe that we have investigators that can't go find somebody and get them to our hearings.
Investigators can't bring them to the hearing, sir.
Did the investigator,
Yeah,
did the
and-
investigator ever go talk to him?
The investigator, we had enough proof without the investigator. The issue we have right now is he's made the statement that he has closed the Tennessee portion of it. We have addresses for him in North Carolina and Tennessee. Those are coming back unclaimed. That doesn't mean he's not there. It means he's not accepting the mail. And what I'm trying to do is clean this up, because if you dismiss the notice of hearing, if you do another consent order, then we are really starting back at the beginning. And when he doesn't sign it, I'll have to bring it back before you for a hearing, which is fine. It's just, again, that would be if the issue is wasting time and money, that's a bigger waste of time.
Well, if we don't have a good address, then
We do have good addresses.
how do we know? He didn't respond.
That doesn't mean we don't have good addresses.
Didn't come back.
It just, we have addresses where the mail was not returned. We have addresses where it wasn't claimed. You cannot claim a certified mail. There's nothing illegal about that. APD rules say when a mail is certified mail, you make the efforts to do additional services, which we did. If we followed the Tennessee law, the unclaimed mail would be considered good service, but we don't follow that portion of the rules of procedure. We have to follow the APD, and this is what we did. North Carolina.
North Carolina.
Brunswick and, well, I'm sorry. Brunswick, North Carolina, and Shallottte, Shallot, North Carolina. That's. And, oh, I'm sorry, what is the third one? That's a different area code, I'm sorry.
But if we vote to dismiss it, we're done with it?
Yep.
There. I-
With these
Maybe-
current complaints.
Maybe what you could,
Go ahead.
maybe close it, and if we get additional maybe instead of dismissing it, because that, that disposes of these, close it if we get more information of where this person is.
Or any further complaints.
So that there would be nothing done to him, right?
Or close
Nothing.
and flag this person's file.
The only thing we can do to him is you issue a consent order, which you did, which he didn't agree with and didn't sign. Then it goes forward to the formal hearing, which is what we did today. So we can't do anything without a formal hearing when someone won't cooperate.
I believe that the renewal date's coming up in the fall. We could maybe flag it if we get a renewal fee, see if it comes with some kind of address or something like that, to where we can pursue this if we can get some more information. If you want, I'm just trying to think up other options.
And you can do that, and which means the underlying complaints would still remain open. And if he renews in the next 2 years, he has 2 years to renew.
Do you have to that's not the right word. Do you have to issue an auctioneer license to an auctioneer who has complaints against him?
Yes. Until the complaints are resolved, you do.
There is a law that I think came through legislation last year, something about if someone had a final order they hadn't satisfied, you can refuse to renew a license, but
That's a
that's not what
final.
we have here.
Right.
It's if someone signed a final order, maybe saying that they would pay a certain amount or do a certain thing
Didn't
and
do
didn't
it.
follow through.
Then we could do it, yeah.
could do it, but that's not what we have in this circumstance. But that is available through the law, just for, if this comes up again.
Well, I'm sorry to bring this up, but I just wanted to clean the record at this point because it remains there, and we have to do something about the underlying.
No apology necessary. We need to take care of business. Anybody make a motion?
Well, what happens if you just leave it on, and we do nothing?
We have to resolve the underlying complaint in one way or the other. There are complainants that are following through with this, including one that was going to testify by telephone today. While they don't have individual rights, they do have a right to know that their issues are being considered by this board.
I think we need to back up and if I understood you correct, if we vote one way, we can go back to where we were. Because I think we overvoted.
No, you've
that.
dismissed the notice of hearing. You can't go back on that. It'd have to start
No,
all over on that.
I think the best our best position, well, I can't say, y'all need, but I would recommend we hear a motion about closing and flagging in this case so that it's still there and we have the option to reopen this thing at some point in the future. What would you make that in the form of a motion, please, sir?
To reopen?
To close and flag that case.
I'll make a motion to close and, I make a motion to close it and to flag it.
It's
To
been
reopen.
Motion's been made. Is there a second?
Second.
Been made and seconded. All in favor say aye.
Aye.
Aye. Howard?
Aye.
Motion carries.
Thank you.
You're welcome. Thank you for all your hard work, Ms. Ryan.
Sure. You'll be seeing me again.
I have the rule information if y'all are ready.
We're ready.
Sorry, I have paper because I just spoke with the AG on Friday.
No
We
problem.
like paper.
I'll explain what they mean in a second.
Thank you for your time, Ms. Ryan.
Second. You'll see that you have one notice of rulemaking hearing, which is the format these were presented to you all before, which says original, and one that says with changes, and they look the same on the first page. The original copy is the rule drafts, the proposed rules that we had drafted and worked on for a while in the form that you approved them for a rulemaking hearing back several months ago, after which they had to go through the department for approval, go to the Attorney General's office for pre-review for constitutionality and other issues, the governor's office, and then at that point we were going to file them for a notice of rulemaking hearing. The one with changes, you'll see I've got highlights on both of them, have got some minor changes to some of the language in a few of the rules that are highlighted, which are based on comments with the Attorney General's office. Essentially, I can go through them one by one. The only one that is really substantive in nature is on page 2 of both of your packets. It's got a star next to it, and it is highlighted. Is everybody starred and highlighted? It's subsection 2, which basically dealt with no auctioneer should accept or shall accept hire for to call bids at any auction by an auction house, barn, or gallery if they did not have a gallery license under the rule. The AG pointed out that the statute was actually a little broader, that the statute specifically stated you did not have to have a gallery license if the gallery was owned and operated by a licensed auctioneer having a valid firm license. So that rule was broadened a little bit just to reflect the language that was in the statute. That is a bit of a substantive change from before, but that is, again, just to comply more closely with how the statute at 62-19-125 reads specifically. I believe it keeps the intent of what you all were wanting, which is just that a licensed auctioneer should not go to a gallery that doesn't have proper licensure, but it's just more streamlined with what the statute says. That's the change there. The next change is on page 4 of both of your packets.
Let's slow down just for a second.
Oh, I'm sorry. Are there any questions about that?
So you're saying we're changing it from the one that's not an A and a B to the one that is an A and a B?
Correct. The one that has the A and B in there is the recommended new language. by
Saying
the-
no licensed auctioneer shall accept offers for hire to call bids at any auction held by an auction house, auction barn, or auction gallery that is not either owned or operated by a licensed auctioneer holding a valid firm license or licensed as a gallery pursuant to provisions of TCA 62-19-125.
Yes, sir.
We were going to change the no license.
It originally
Hold a
just,
valid gallery okay, all right, so this makes it a little bit more clear.
It reflects
That-
more like what the law says.
Right.
yes, in going through there,
You gotta find.
it is something that I'll take the blame for. I had just overlooked that. We talked about requiring, the problem that we had addressed was people not having gallery licenses,
Right.
and that's how it was drafted. But she pointed out that in the very bottom of subsection A of 125, it did say that in certain circumstances that the gallery license wasn't required. And this rule is, the wording here is changed to to address that one circumstance that may happen on occasion.
Or
And
you could have a valid gallery license and still be hired, or you could have a auction barn or auction house that's owned and operated by a licensed auctioneer,
who has a firm
which
license.
has by the firm.
Yes, sir, and be in compliance with the statute. So the
Okay.
rule is just changed.
All right.
And I have these.
And we don't have that law now.
It is in the statute, but this rule, the statute requires that to have if you're operating an auction house, barn, or gallery, you need to have a gallery license. But one is not required if it is owned by a licensed auctioneer with a firm license. This rule you all had asked for was to address the individual who might go to a place of that nature. I believe we saw a rash of complaints for unlicensed galleries that there
Right.
may or may not have been a licensee calling those auctions, and this was to put a little bit of the duty on that licensee to go, hey, where's your gallery license? Or
Got it.
hey, where's your license? And these have not been changed yet. I spoke with the AG on Friday. I'm addressing these all with you at the end of these. If you all are okay with the changes that are highlighted, what we'll do is by voice motion, accept those or not, I'll let the AG know, and the process will continue, and these will go up to the governor's office.
What's the next change?
The next rule is on page 4 of both packets. It is from the rule that is drafted, the titles on the previous page, which would now be titled non-auctioneer owned firms. Essentially, these are just wording changes. I can let you read through the two changes of them. The AG just thought that somebody that's not familiar with the auction industry might get a little confused with the wording. It doesn't really change the meaning or intent behind these. The goal with her suggested changes that we discussed is just to make them clearer, and that's reflected in the packet that says with changes on the first page. The original, like I said, is how it was worded before.
What's stricken out is what's there now, and what's underlined is what we're adding.
Yes, sir. And the one that you'll see that's got some strikeouts and some additions was the original one. So the AG just thought it would be a little clearer. I was trying to maintain as much of the original language that was in the rule currently that is in effect as possible. She thought it was better to reword these a little more in depth than I had originally, just to make what we were trying to do more clear to someone reading them. There's not really a substantive change in those three subsections that I can describe to you. I'm sorry, the red lines are a little bit confusing to read. The new one should be a little easier because I just stroked through the whole part and I just wanted to make you aware of these. The same thing is true of the rule that's just below that, that's also highlighted, proposed rule 0160-01-.24. It's just a rewording to make it a little clearer. It still requires notification within 10 days and having no longer than 30 days to replace. It's just,
This is more grammatical changes than it is
yes, sir. The
fundamental
rest, except for the
changes.
one that was starred there, mostly grammatical, but because these would be changes that the AG recommended, I wanted to make you all aware of them before I made the changes in going forward. The same thing is true of the one titled escrow account requirement. Yes, sir. Yes, sir.
Since I've had an auctioneer license, and it's been a while, I've been told that you have to open an escrow account, but you don't have to use it. That's been brought up at the commission numerous times.
Well,
Don't have to use it.
You don't have to.
there is.
If you don't, it's commingling of funds.
Yeah, there is a disciplinary action that, right now, in the commission's issue, the reason why this rule is specifically stated out was the law did not have a specific statement of this type. However, within 6219.112, subsection B4 does make it possible for the commission to issue disciplinary action for failing to account for or remit within a reasonable time any money belonging to others that comes into the licensee's possession, commingling funds of others with the licensee's own, or failing to keep the funds of others in an escrow or trustee account. So there is disciplinary action for not doing it currently. However, we don't have a statute that specifically states out that you shall do it. So that's why the commission had asked for this rule to help clarify what's already required, but just in a roundabout way by this.
It's required.
If at the auction, and there's a lot of auctions that do this, when the sale is over, they pay the people who sold. Money never goes into an escrow account, it switches out right then. That's the question that we've had. If you come to my sale and buy something and Susan is the seller and you pay me for what I sold, what you purchased, and I pay Susan immediately after the sale for what she bought.
Still, if you're writing checks, those checks should run through an escrow account, not an operating account.
Are you talking about if someone's dealing with cash at the end of the sale, perhaps?
If you run your money through your operating account on that basis, that's commingling of funds, even if it's for a nanosecond.
Okay. I don't do that, but I just noticed that.
Commingling is commingling, it doesn't matter how long, there's no time requirement.
I remember back when we were discussing this rule that there was somebody that brought up, like, if it was just cash. And, in that case, obviously, you wouldn't be using your account at all. But the way that you all had asked the rule be required, that if anybody was holding funds of any type, bringing them into their accounts, that it would be.
So what you're saying is that every penny that's taken in from an auction is to be put into an escrow account and dispersed
From an escrow.
from that
account.
escrow account.
That's
Is
correct.
that
The
what
way
you're saying?
Absolutely.
The way the disciplinary statute reads, if you keep the funds of others should be kept in escrow or trustee account. So that would mean if they go into an account, if it belongs to someone else, it needs to go in your escrow or trustee account. That's how the statute is even worded now, so.
There's no length of time requirement on that.
Cash that goes into I was just thinking if you were making.
I like that rule myself.
Then the next one is 0160-01-.27 is the title of the proposed rule, livestock auction sales. Again, this was just one that was somewhat unclear to the AG, the way it was worded. We tried to arrive at it where she thought the language was a little more understandable without changing any of the meaning or intent behind any of the sections. I'll let you read through it, but it's not, again, intended to be a substantive change at all. It's just for clarity that the different language was suggested by the AG's office. And the last proposed rule that had any changes at all by the AG was the last highlighted rule, which is titled online auctions. And again, it's just a few words that she changed, not really anything to change the rule that was already there. It's the final one, so. The only ones that had any changes at all are highlighted.
This is a little, this might just be me, and I don't know if there's a better way to say this, or if it's too late to do it, or if what's there is fine. And like I said, this just may be me, but I think this one is one of the most important ones we got going in here. But the thing that's a little bit confusing to me is it says if the time for an online-only auction with fixed bidding time is extended beyond the online auction's fixed ending time, then the auction and the person conducting the auction are not included within the exemption specified in the okay.
Which is the E-Day exemption.
But I understand, I know exactly what it does and what it's there for, but it says, should that be, this may just be me, I don't know, rather than if the time for an online auction with a fixed bidding time is extended beyond the online auctions, I mean, is fixed the right word right there? Yeah, or should it be advertised ending time?
The
or-
reason why it says fixed is because that's the language used in the statute. The actual exemption says any fixed priced or timed listings, and so it's meant to tie in with the statute
That's
as
right,
closely
it's-
as
okay.
possible. Yes, sir. If that answers your question, that's why that was.
So they go
I just
beyond,
wanna make
they
sure
go
it's
beyond
right.
30,
I
they go
understand.
beyond by 1
Oh,
second.
yeah.
It throws them off.
And
the-
from what I understand, a lot of those programs do that.
Yeah.
Extend it.
Right.
Do you have to be a Tennessee licensed auctioneer to conduct an online auction?
No.
Right now, the exemption, if it falls in this exemption, you do not have to be licensed. That's how the statute. There's a number of exemption. There's 9, and if it falls in, if your actions fall within one of these exemptions, that's what they're meant to do. But the problem we were seeing was somebody saying it was a fixed time, online-only auction, and then the minutes were creeping up. They were extending. You know, it comes up to 15 seconds left, and another minute would pop on there, then another minute. And what the
think a lot
commission
of-
wanted to address is, this is not meant to be included within this exemption. You're not fixed time anymore. Does
I
that
think a lot of them
explain-
have one, like if they bid in the last minute, it extends 5 minutes or something like that.
Yeah,
A lot
the
of them.
time was perpetually extended.
Ours, the way we do it, if it ends at 6 o'clock Saturday afternoon, if that's the ending time, then that's when it starts ending, and it ends every 2 minutes. There'll be items go off every 2 minutes for another.
But the difference
Hour and
is
a half of it.
you have a Tennessee auctioneer's license.
I know.
So you can do whatever you want.
This is just for those firms that are trying to fall under the exemption that doesn't require them to have a license to be able to do online-only
I mean, there's
auctions.
websites out there where people can just go and
Right.
Until it's regulated and they have to have a license. I think this is kind of like to getting somebody to come down here from North Carolina. We're wasting our time. But I like that.
it can't hurt.
That's right.
We've got to start with baby
You-
steps.
If you all are okay with these wording changes that were included in this packet, would you mind doing by voice vote just a motion to accept the changes or not, depending on what all you would
The
like to?
motion
So I
for
can,
that?
yes, please, so I can let the AG's
I move
office.
that we accept the changes to the notice of rulemaking hearing.
I'll second.
Been made and seconded. Any other discussion? All in favor say aye.
Aye.
All, motion
Aye.
passes.
Thank you very much. I will let her know. I don't believe they had any other issues with it, so at this point, it should be going to the governor's office, and then after that, I'll be calendaring it for a rulemaking hearing at one of our meetings. So if you all have any, now, it's got to be noticed for around 55 days, I believe, from the time I notice it, and I'm not sure how long it will take me to get the governor's approval, but do you all have any months that you would definitely not want that to be scheduled at this
Probably
point?
July.
Do we have a meeting in July?
That's the NAA.
With the amount of time,
Yeah, we
I
don't
don't
have-
believe
We
that,
usually don't meet in July anyway, so.
I don't believe I would be able to have the requisite approval and have
Or
the
June,
notice
or
time.
You won't have it by then.
No, it would probably be at least August before, just to comply with the statute.
You do have a July meeting scheduled, July 1st.
Either one.
There's not one in June.
Well, that's-
What about
the
Sep- what
convention's
about
not on
August?
till the middle of
There's
the-
not a meeting in September.
Why is there not a meeting in June?
Conflicted with the
TAA.
TAA.
summer conference.
Is it on Monday?
Actually, this year, I don't think it does conflict, because I think the convention's the second weekend instead of the first weekend.
Says usually conflicts.
The convention is.
But it doesn't
Convention is
conflict this time.
August 8th through 12th.
No, I'm talking about the.
I mean, I'm sorry, June 8th through 12th, I'm sorry, is the TA.
8th is on a Monday.
That you couldn't have
TAA.
that ready by
So ours will
June
be on
anyway.
No,
First.
I would not be able to, I mean, get approval from the governor's office and have this
It's not
notice
gonna
as
happen
long,
that fast.
I think it'll be at least August. I just didn't know if into the fall there was gonna be a meeting that several people didn't plan, had
I'd say
conflict.
either-
I might have a conflict in October, but it's too early to tell.
Okay. And I can always ask that, if once we get a more determinate date, that somebody send an email to you all to respond individually to someone
I
on
would
staff
shoot
to
for
let
either
you
the
know.
August meeting or the October meeting.
Okay, great, thank you
One
very
of the two.
much. That's all I have then.
Not October.
Clear me up on when the meetings are and are not.
We don't have one in June. We do have one in July
But
and
we-
August, and we don't have one in September.
But it's not, the first Monday in June
Oh,
is
wait.
not the date.
You adopted the calendar last year.
I'm sorry, there is not one in July. I was looking at 2013.
That's what I thought.
You got two months that you're not gonna have a meeting.
July and September.
July and September, we have one. in
We are
June.
having one in June.
Yes.
Okay.
Yeah, June the 2nd.
I apologize, I was looking at the 2013 calendar.
Yeah, July and, I knew we skipped 2 months, July and September.
And the convention is the 8th.
Right. So we'll be here June the
Yeah, yeah,
2nd. In fact, I've already booked my hotel room, I think.
I possibly won't be here in June.
Howard, you gonna be here in June?
I don't know.
Bobby?
Ronnie's gonna have some.
Got another surgery May 15th.
Three of us can get together in June and have a meeting if we need to. We'll see what the calendar looks like.
I won't have the approval
We'll-
back and notice by then, but
As always, we'll,
Yeah, we'll
yes,
we'll
Mr.
look at
Phillips,
it and see
we'll,
how it-
we'll evaluate the amount of business if
Okay.
it warrants.
Perfect. Okay, if you want to go ahead and do your administrative report.
Yes, sir. Okay, on tab 3, you have your complaint comparison report. The commission is doing very well at 97.37% of the complaints being cleared for legal action within 180 days of receipt.
Still got that one case sitting out there that skews those numbers a little bit, I think.
Yes, sir.
Tab 3.
Yes, that actually skews the number that you have open,
Yeah.
not your
but not your
percentage.
performance measure.
Gotcha.
If there are not any questions, I'll move on to your budget report on tab 4. And again, this is just for informational purposes. The first page is the revenues through March 31st. The second page are the expenditures through March 31st. And the final page of that deals with the auctioneer recovery fund. And it has the revenues and expenditures on one tab.
What's the balance in our recovery fund?
I do not have that in front of me, but I can certainly bring that to the next meeting. I can tell you as of,
I know it's in compliance with.
yes, we are still.
What's our minimum, 150?
Yes. I can tell you as of what it was as of June 30, and we were within the
Okay.
compliance.
Yeah, I just kind of like to make sure we're
Yes,
staying
I will
in
certainly
compliance.
make sure next month that I provide you with the tab with your
Okay,
balance.
perfect. Continuing education course
Yes.
provider, tab 5.
Yes, this is actually a course application, and this is for the Nashville Auction School for a 3-hour class entitled Kick It Up. There's an app for that. You have the first page with a short description, and they provided the detail of the course as in an outline, as well as the actual slides for the course. And then the instructor information is followed behind that.
You want to speak to that, Wendell, at all?
That way you don't have to walk over there.
Cool. Kimber, typically the way we submit courses is we submit them to the board and they approve them. They don't have to go to the board. So this is a little unusual for us in the way that we've submitted courses in the past. So if there is a change on the way that we submit course approvals, I would like to know as far as an educator, so we'll know how much lead time to allow before we present a new class and can give credit for it. This is a great course. It deals with apps in the auction business, and it's really snappy, and I did a lot of research on it, and it's a really
It sounds very timely. I don't know what the requirements are, Julie. Can you?
Sure. There had been some confusion in the past that Kimberly and I had looked into, got in there, got our feet wet, our hands dirty, and examined the rules a little closer. And the rules appear to clarify, and we want to clarify the process going forward, that the rules do require that formal programs, the rule qualifying programs, which is 0160-03-.04, subsection 2 of that rule states that a sponsor of a continuing education program shall obtain approval from the commission as provided in the chapter. Just below that in subsection 3, it goes through requirements for a program requiring attendance that they may only be considered for approval by the commission if a number of factors, there's 4 of them, are met. We did want to clarify the process that the rules do, as they're currently written, appear to require that the commission approve any courses that are going to be given for credit. And Rule 0160-03-.05, which is entitled Sponsors, does address the time frame for submitting those courses for approval. It requires that the sponsor of a program shall apply for approval of the program by filling out the commission's form at least 30 days prior to the program being offered for continuing education credit. So our rules do, as they're currently written, appear to be pretty clear in that regard. And so in just trying to eliminate the confusion that there was in the past, we do think the rules require that the commission does have to consider each of these. So.
In 15 years, I've never, this is what surprised us last Thursday when you called, wanting additional information so you could present it before the commission, because in the past, for 15 years that I've been doing continuing education, we've just simply submitted an outline to the commission, and the office has approved the course and assigned us an educator number.
Understand that.
So if we're
It's for
changing this.
clarity.
Yeah, if we're changing this, I need to know to allow time frame on a new class coming out to be able to educate students.
In the past, historically, we would approve the provider, and then when the courses came through, they were automatically approved and issued a number in,
Right, once
in the
that's the way
office.
I thought it was, is once the provider was
Right.
approved,
But
anything.
in reviewing the rules, the rule requires,
That each course be approved.
I mean, the only way that I've checked with chief counsel to change that would be to change, this is coming from a rule, not a policy. The rule says that someone shall obtain approval from the commission. Shall. It's not a lot for
Which
me
this
to
may
work
be.
with.
I think we've just been sliding by, Wendell, is what we've been doing.
Well,
It sounds like it, doesn't
well, and then, but now,
I just
I hadn't
believe there
got, what
must have
does the
been
law
some.
say, what does the law say? I know there's something in there about approving, that the NAA, anything that the NAA puts on is
That's in
approved.
subsection 10.
And then,
It's
how
kind
does
of
that read?
lengthy. You want me to read it to you?
It's short, isn't it?
Notwithstanding any other provisions of these rules, to the contrary, the requirements of Rule 0160-3-.05 sponsors and paragraphs 2 and 3 of this rule shall not apply to sponsors the Commission determines are nationally recognized providers of auctioneer education. Those sponsors shall comply with the provisions of Rule 0160-3-.07 Control and Reporting System. The failure of each sponsor to report as required shall result in the Commission's refusal to grant credit for attendance at programs of such sponsors and/or the suspension of the sponsor's recognition by the Commission under this paragraph. For purposes of this paragraph, the nationally recognized provider of auctioneer education is the National Auctioneer Association. So basically, if the National Auctioneer Association is the sponsor of a course, then the National Auctioneer Association gets around that requirement that we
Well,
discussed.
see,
But the only-
but the only reason I was asking about that is if it's anything that the Nashville Auction School does is approved by the National Auctioneers Association as a nationally recognized provider, so, yeah.
We jump through a lot of hoops. Every course that we write, and we spend a lot of time and research in courses that we write. And Commissioner Phillips was on the board when we were the first to introduce online continuing education to the auction world, and thank you for your approval back then. But every time I submit a course, this course is simultaneously submitted to 13 other states for approval. So I am an instructor for the National Auctioneers Association, and they rely on me for approval in states where they don't have approval.
Licenses.
Approval,
Yeah.
such as Illinois, Wisconsin, and Texas. So I am their source for education and approval for those courses in those states.
How do we get around the rule?
There's not.
Well, I move we approve this course right here that was just presented to us.
Well, I have one more question. When you refer to the commission, are you referring to the auctioneer commission, or are you referring to a commission upstairs? Which commission are you referring to?
The commission is the
It's
auctioneer
us.
commission. Commission shall mean the Tennessee Auctioneer Commission. It's defined within the same section as that rule. So,
But the rule says that we have to approve every course.
unless
that-
the sponsor
unless
of
it's-
the course is the National Auctioneer Association.
They're the only ones exempt under that rule.
That's how your rules are written, and unfortunately, I mean, I've reviewed this with chief counsel in a meeting. This would have to be done by a rule revision.
Okay.
That could have been changed in these rule makings that we did.
It's too late to add it now.
I mean, it's too late for this rulemaking.
I mean,
It's-
but it'll come up again.
we can put it on a list for a future rulemaking, but yes, this, it would really hold back the rules that we've already got, because
Right.
they're scheduled to go up to the governor's office, and we would have
So
to.
that's where we are, Wendell.
I'm fine with that, as long as I know a time frame.
Right.
Because we were ready to introduce this course, and then last Thursday, I guess it was, Ms. Kimberly, Thursday or Friday, we get, it might have been Wednesday.
I
But-
think it was Tuesday or Wednesday.
Yeah,
but
we get a call from
either
the
way.
commission office saying we need more information, and then it has to go before the commission. Well, it's never had to do that before.
But the
And-
commission doesn't want to entertain a lawsuit from another vendor.
Well,
I
and
apologize
And the
for that.
commission don't want to approve every one of my courses either, so, I just need a time frame and
Right.
how to schedule courses and when they become hot.
Well, now we know.
As active.
I apologize for the confusion.
There's been a motion made to approve the course. as
second the
written.
motion.
It's been seconded by Howard. All in favor say aye. Aye. Your course is approved.
Thank you.
Unfortunately, that's where we are.
That's the way we'll be.
All right.
I'm fine with it, as long as I know.
Yep. Now you know.
Yes, and the items that, the rule is very clear about the items that are required, and that's what we were clarifying, was
I'm-
making sure the commission had enough information. So,
I'm very fine with that, just as long as I know going in, because like I said, this was gone to 13 other states at the same time.
All right, next item is item number 8, tab 8, I mean.
actually, tab 5, 6, and 7 are
Okay.
courses.
Oh, we got to
They're
go, we
separate
got,
applications.
separate deal, okay.
If you will flip to tab 6, this is the Auction School of Technology. And this is actually a represent. The commission voted to table this matter. We do have the course information if the commission would like to review it. It is as it was at the last commission meeting. We do not have any additional information.
Did they make any changes to it at all?
No, sir, there were no changes requested by the commission and no additional information.
I think you all had tabled it just because you weren't quite, you wanted to think on it until the next month. Miss Whaley had asked if she could collect any more information, and you all said that no, you'd just like to reconsider it this month after you'd had a chance to think over some of the information that you first saw last month.
I do have the course material. It is a little lengthy, so there's an abbreviated version on your iPad, and I have the hard copy if anyone would like to examine it.
This is an online course or not?
I think it is.
Where are they from?
Georgia. Let me see the
Oh, not at all.
I was
There
scanning.
you go. Yes, sir.
I'm reviewing
You
this.
received it last time. I don't think you were here. You might ought to glance at it too.
Yeah, he took our own law
Google
and,
stuff and.
yeah.
Took our law. Hours.
It does say 6 hours on the application. Yes, sir. Actually, it says 8.
Eight.
It's approved in Georgia for 8 hours, but they're asking for 6 hours for Tennessee.
Can't go to the internet and pull down and.
Kinda what it was when I looked at it. That's the reason we tabled it.
Julie, is there anything in the rules or policies or laws that tell us what the minimum requirements for a course are?
Yes, sir. Do y'all have do they have the rules in their book? Rule 0160-3-.04 titled Qualifying Programs.
E04.
Oh,
Okay,
for
there
it.
it is. I got it.
Do you see it?
Page 2 under the rules here.
I'm sorry, I have my book I carry around with me, or I would have told you the page number. It's titled Qualifying Programs, and the factors that you would consider for a continuing education course are under subsection 3. It's A through D. And because this appears to just be an online course, I feel like, I mean, if this is something you want to consider too, it's a factor. Subsection 5 of that same rule says that formal correspondence and other individual study programs which require registration and provide evidence of satisfactory completion may qualify for continuing education in an amount to be determined by the commission. I don't know if in looking in these materials, if you all feel like, maybe there's not enough to cover as much time.
What assurances or what third-party providers does this applicant have to say that somebody is on their computer for 8 hours or 6 hours or for whatever?
I don't believe that there are any. That's why I think that they provided the course information. If in looking at the commission, determines, well, I don't think there's any way it could take this long, it appears that 5 allows you to qualify them for education credit in an amount that you all determine to be appropriate, because we don't know, I don't know of any way, and the rule does not address any way to be sure of how long someone's on the computer, and everybody reads at different speeds and comprehends at different speeds.
Right.
But I can imagine every course would be different in what you get, and if you get something that you just feel that there's no way it could fill the time, or conversely that you feel maybe would be worth take more time.
Based on the materials that I'm looking at, I don't know how he could convert that into an online learning environment without providing some kind of here's the material, here are the test questions or something like that. And I mean, we don't have any way of this guy confirming that these people have completed this course other than spending the time on it. I don't see enough evidence here that would denote that that would be an online course as such, other than he's copying and pasting stuff off the internet saying this is what I'm going to teach these people, but there's no transcript of what they're going to read.
I make a motion that we don't grant this because of the lack of information.
Motion been made. Is there a second?
I'll second.
It's been made and seconded. Is there any more discussion? Call for the question. Anybody, all in favor say aye.
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 Motion passes.
You say aye?
I did.
I would direct that applicant to, he would have to beef up, if he wants to know what it's going to take, that it's going to take more in terms of assuring that people are online for a period of time, and that the material to be covered has to be in a format that would be in an online fashion, and we would like to see a copy of the test and test questions in terms of how they plan to ascertain whether they've comprehended what they've read. Go for that one. Okay,
One more under tab.
and we have another one,
Yes.
and that would be
Under
tab 7.
This is the TAA Spring Continuing Education block. They have requested for 3 hours. They have 3 separate pieces to the course in 1 hour increments. They're included there. There is an agenda related to the meeting. And we have the bios of the
Two instructors and their.
2 instructors and the license information.
They're trying to get this approved for the June meeting.
Yes, sir.
Oh, I can't never, go ahead. I have cold hands or something.
Well, I don't. My fingers are warm as your heart.
No, wait a minute, go library. Now go 7.
This is a course that Justin Oakes and Tim Master are going to put on for voice care and creating a competitive bidding atmosphere. A 2-hour course. Is that what you-
It's actually a 3. There's a
3.
third piece, key to a successful real estate auction.
Oh, okay. All right. That must be Tim's section.
According to the
On the
outline,
agenda.
that appears to be the case.
There's the agenda.
My way of thinking, this kind of goes back along with what I was saying earlier about the NAA with the nationally recognized providers and all that. You're talking about 2 guys right there that are definitely recognized by the NAA
And the TAA.
And the TAA is also recognized by
Right.
the NAA, so I wouldn't have no problem approving this at all.
Did you make that in the form of a motion?
I did, I will, I have.
It has been moved. Is there a second?
I'll second.
It's been made and seconded to approve this course for the June meeting of the TAA. All in favor say aye.
Aye.
Motion passes. They've been approved.
Sir, one note, we are, and again, we realize this as well, we're actually going to be looking at revising the form and bringing the continuing education form to the board. That way, the providers do understand what the commission is requesting and that the forms comply with the laws and the rules.
Perfect.
So we're going to be working on that between now and the next meeting, and that, I hope, will address Mr. Hanson's concerns about knowing what needs to be presented as well as the time frame in which to present.
So I'm to assume, Ms. Kimberly, that everything we've submitted so far is still approved?
Yeah, they,
Yes,
they
we're not
approved
gonna go-
your course that you sent in.
Yes, we're not.
Okay. you're
No,
not
no,
gonna-
we're
We
just
can't-
trying
that's
to
already-
clarify our form
The-
to more
any
clearly
new-
ask, so you won't be
Right.
contacted on the back
Any
end.
new courses would have to meet this criteria. Not-
yes, it's
Not
the-
the old courses
It's
that you've
that, and
already
I,
approved.
just for clarity, the criteria has not changed. It is just the presentation of the criteria, the form, and making sure that it's very clear to the providers what the commission needs to see, such as with the online course, that they clearly know what it is the commission wants to see as far as the,
Why,
I suspect this was probably
To-
a shock to the TAA too, because they've never had any trouble. It's always just been approved and went on anything that they've ever done, so.
they were very nice and very cooperative, and
Be mean.
what,
they
Why-
understood, and I explained to her the laws and the rules, and they were very, very nice about it.
when a provider has something that they want to get presented to the auctioneer commission, why is it not possible for them to come here and sit down and tell us what they're doing?
It's just not
Anybody can
required.
come to a
Certainly
meeting.
they certainly, just as Mr. Hanson is here today,
Always here.
right,
These are open to the public. If
Yes.
somebody wanted to come and the commission wanted to recognize them, it's up to you all if you want to.
I'm talking about this guy from Georgia that wanted us to approve this online auction. He sends you a package in here and fine line print. It would be more if he came over here and sat down at the commission and said, this is my program.
Right, but that's just not a requirement. All we have is in the rule, the information that's required.
And we have had some that have come when they've done something.
Correct, yes.
Yeah.
But it's not a requirement, and,
Right.
you know, for some people, depending on how far away they might be teaching a course, that might not be possible.
Guess it's just their business decision whether they won't come or not.
so we'll be bringing those forms to the next commission meeting, which leads us to tab 8.
Eight.
And actually, this is the form for the 80-hour course that we have revised, and we're bringing that to you for you to review and look at, and if there's any additions or changes.
This form was amended to more strictly follow the requirements that are already set out in your rule for auction schools, which is a separate rule from your continuing education qualifying courses rule. It's Rule 0160-01-.10 entitled Auction Schools. That sets out the requirement for an auction school to be approved by the Auctioneer Commission. It lays out 7 requirements of things that must be demonstrated, and this form is just meant to more clearly capture all of those requirements of that rule so that someone submitting an application can know, hopefully just by looking and familiarizing themselves and completing the application, what they need to provide, at least to give you all enough information to make a decision regarding an auction school.
With this form, I know it's on your iPads. If you would like, we can email you a copy of the draft if you'd like to look at it between now and the next commission meeting, if you're not ready.
I think the form's fine.
Okay.
Do you just
This
adopt
is-
it, or that's just, I mean, just something administratively y'all are gonna do anyway?
Forms have to be approved by the commission.
Is this a new form or is this?
It's a revised form. We started over to add more information to it, but it is a revised form because there is currently an application
We don't know what the
out
old
there.
form looks like, though.
Oh, I'm sorry, I don't.
So we have one from,
You reviewed one at the last meeting. I think there
Okay,
was,
I'm sure we remember that.
it was tabled.
But what this form does is it lays out exactly what they have to provide, where the old form did not. Is that correct? Okay,
and it,
Old form don't have much of nothing on it.
I know.
yeah,
The
and
old
I-
form is not as thorough as we thought would be helpful to somebody submitting. I mean, it's not as if it's,
All of these,
Incorrect. It's
all of
just
these
to-
points that you have here under the items required, that stuff that's out of the law that, like the, pass-fail grading system, have a permanent business location.
Yes,
and
sir.
all
Those
that.
are all
That's not
banned from the
anything
rule.
new in there. It's
No,
all-
sir.
Well, I
And
think this is much better.
If you've got your rules, I can give you the rule number if you want to look to it. There is a
I
specific
trust you.
rule.
And they're pretty much in the same order as the rules.
Okay.
It's very closely
This-
followed to the rule.
This will allow us, as the staff, when someone calls in and asks a question, we can direct them
They
to
can
the
just grab
rule.
that form and look at it and,
And we can point them to the rule, as well as attaching the additional documents at the bottom. If you'll notice, the old form just had a little bitty tiny box that
Okay.
you could put 5 words in. So this asks them for what?
I move that we approve the new form for the auction school application, 80-hour course initial education for apprentice auctioneer.
Motion been made, is second?
Second.
All in favor say aye.
Aye.
Motion, the form is approved. Tab 9 here.
And I will make a note, there was last month we presented an 80-hour application for the Ohio Auction School. That matter has been deferred. The owner of the school has been ill and was unable to provide the additional information that was needed, so we will be bringing that.
We'll be here in June, they can bring it back.
Yes. Next you have on tab 9, and this is a request to waive the requirement that a sponsoring auctioneer must reside in the same state as the apprentice. This comes from Mr. Hanson. You have a letter from Mr. Hanson, and he is here if you have any
Brenda,
questions.
won't you speak to this?
Okay. Basically, what this boils down to, Joel Morrell, a good friend of mine. I've known him for 10 years. We've done auctions in Delaware, Florida together, where I'm licensed to. Delaware is a non-licensed state. But Joel's hit a tough time in his life, and he has farming obligations in Nebraska. He wants to move to Tennessee. He can't yet. And I told him I would appear before the commission today on his behalf and my behalf to ask permission for him to go ahead and take the Tennessee apprentice test. Now, Joel has agreed. His basic education is from Worldwide College of Auctioneering in November 2002. I've included a copy of the rule here that allows you as a commission to waive that rule. Now, be aware that Joel would never do any auctions in Tennessee. You can't do any auctions in Tennessee because he's not a Tennessee licensed auctioneer or apprentice auctioneer, but he wouldn't do any, and I'm looking to hire somebody in my company too as an apprentice, and Joel would be under my sponsorship, which is a big obligation, as you know, to be a sponsor for an apprentice. But the rule says, and I've included a copy of the rule for you there, all sponsoring auctioneers shall reside in the same state as his or her apprentice auctioneer. However, in appropriate cases, upon good cause being shown, the commission may waive this rule. In order to show good cause, I've noted 4 tabs near the bottom of the page for you. I've held a personal and professional relationship with Joel Morrell for almost 10 years. Mr. Morrell is considering relocating in Tennessee in the future. However, he currently has seasonal and family obligations in Nebraska. He would be under my direct supervision on all auction activity engaged in the state of Tennessee. And also, when we were looking at this, we looked at other opportunities where he could apprentice for Tennessee license under someone that's already a Tennessee license in Nebraska, so they could reside in the same state, which what our rule directs to. But there's only 2 firm licenses, Tennessee firm licenses located in Nebraska, and I can name names if you want me to, but both of those firms are large corporate firms that have employee auctioneers. Joel's a contract auctioneer. I do some contract auctioneering too, and that's why we've worked together. Also, if you grant this apprenticeship program for Joel that lives in Nebraska that would be a Tennessee apprentice, Joel's agreed to attend a 30-hour education course in June in order to become it, which is one of my obligations too. The apprentice unless he was familiar with Tennessee law. So he would attend the 30-hour course, which is required before you transform from an apprentice into an auctioneer. But in my research, and prior to 4 years ago, y'all gave licenses based on experience. If someone from a non-licensing state had had 5 years of experience as an auctioneer, you would let them take the 30-hour course and take the Tennessee auctioneer exam. That's gone away over the past 4.5 years. So what I'm asking for is to allow Joel to be an apprentice under me. He would only be doing auction activity while he's in my presence, and I guarantee that. We have 363 out-of-state non-resident auctioneers in Tennessee. We have 55 auctioneers that are licensed in Tennessee from non-licensing states. So, and that's how they became licensed. Before we started making them, the commission started making them do the apprenticeship program, y'all would give a license based on 5 years of experience, and you no longer do that. So Joel has no other way to get a Tennessee license because there's none of the large corporation firms would allow him to apprentice under any of them. And so this is kind of a last resort for Joel, and he asked me if I would consider doing it with him, for him. And that's why I'm approaching you to ask permission for him to apprentice under me, Hanson Realty, and to be my apprentice.
Like a compelling
Ask a
case?
question, just because I was confused. I didn't understand this from the letter, but is this person not, if approved for you to be his sponsor, is he not going to obtain licensure by doing the 80 hours of instruction through
He already has the 80
Oh,
hours.
I'm sorry, I
Got that from
misunderstood.
Worldwide.
He attended
2002.
Worldwide College of Auctioneering in November 2002.
I'm
So
sorry.
he has the basic education, and he's licensed in other states,
Okay,
but he's not licensed in Tennessee.
Okay.
Mr.
I'm
Hanson,
sorry. I said-
having been on the commission for, I think, like 12 years, the only time that an out-of-state apprentice has been approved was one that was on a state line,
Sure.
and there was not an auctioneer close to him until the other day when the commission granted a apprentice auctioneer to be under a out-of-state licensed auctioneer. That did not, in my opinion, fit the criteria, neither does this.
I respect that.
And I think that what's happening is, and you know I love you like a brother, but I think what's happening is, if we continue this, our apprentice program will be in 48 states.
Well, what this rule allows you to do in appropriate cases, and I hope that I've shown an appropriate case to you, he has no other options. And if he has no other options to serve an apprenticeship program, I mean, you're looking at almost a restraint of trade if you're not allowing someone else to serve an apprenticeship program that wants to. And I think I've shown appropriate case that he can't get it any other way.
I understand, and you did present a good case. And you making my little brain I've got, you're making it turn a little bit. But there is another alternative. He could move to Tennessee.
Then he wouldn't need a waiver, Commissioner Phillips.
Correct.
He would be a Tennessee resident. I'm asking for a waiver from the rule.
A lot of people has got the reciprocal license rather than doing something like what you're talking about doing too.
Well, he can't get a reciprocal license because he's from a
It's a
non-licensing
non-licensed
state.
state, yeah.
I mean, y'all have given, the commission, not y'all, the commission has given reciprocal license in the past to people with 5 years of experience. He has more than 5 years of experience.
Well,
But at this time, y'all will not grant a reciprocal license based on experience. That's why he's asking to serve in a 2-year apprenticeship program.
Agree with Wendell and Howard both, you know, I mean, if it's the rule, but, you know, if you're gonna keep waving this and waving that, cause a lot of stuff, I think. But if it's the rule, it's the rule.
And you all do have the discretion in the rule if good cause is shown, which doesn't mean that by approving this one, you have to approve the next one that comes along, because all circumstances are different, and I believe that's why that rule is drafted that way.
Does it say,
I'll read
does
it.
the rule say hardship or?
I believe Mr. Hampson captured it in full in his letter, but the full text of the rule, just reading it directly from my book, is all sponsoring auctioneers shall reside in the same state as his or her apprentice auctioneers, auctioneer with an S in parentheses. However, in appropriate cases, upon good cause being shown, the commission may waive this rule. And that's really all the subsection says about that, that in appropriate cases.
Do you have a definition of good cause?
There's not one within that section. Our definitions within that, I don't actually think we have any section definitions. So it's left up to you all's judgment of whether if it is appropriate to consider a waiver, if good cause has been shown.
What was you talking, Howard, about the one that was just approved? Oh,
And really, it would just be on the facts that Mr. Hanson's given you here, and he's laid those out at the bottom as to what his reasons are for asking for the waiver, and that's really what the rule requires you to consider.
I wonder if anyone's ever been done that wasn't at least an adjoining state, even if it wasn't right on the line like what Howard was talking about.
There was two cases. Both of them were in Tennessee and on the Kentucky line, and it was 50 or 60 miles to the nearest auctioneer, but right inside the Kentucky border was an auctioneer, and we granted this person permission to apprentice under the Kentucky auctioneer. And since this guy is going to do no work in Nebraska, right? No auctioneering work in Nebraska.
He's an auctioneer. He has an auction company in Nebraska.
Sorry, I rephrased that wrong. He's not going to do any auctioneering in Tennessee unless he's with you and your supervision.
He can't do any auction activity unless he's my apprentice. He can't do now. I mean, he's not a licensee and he's not an apprentice. So I know how strict you are in your company. You know how strict I am in my company. If somebody does something wrong, they won't be working for me very long, Howard.
Chair will entertain a motion one way or the other, guys.
Since knowing Mr. Hanson and expressing my opinion, which I think is correct, I believe under this circumstance, I will make a motion to grant the apprentice school to take his 80-hour course. And
They're taking the
Yeah, but the 30 hour.
30-hour course, and Mr. Hanson will be his sponsoring auctioneer. Is that correct? That's correct.
Right.
I'll second.
It's been made and seconded. Is there any further discussion? All in favor say aye. 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 Motion passes.
I have a educator report at this time, late
All right.
breaking, if y'all will entertain that.
That'd be fine.
And thank you for that vote. This is my educator report. The Tennessee Auctioneer Commission Seminar is upcoming on Monday, May the 19th at Montgomery Bell State Park from 9 a.m. to 4 p.m. Central Time. Justin Oakes will be presenting on voice care and psychology of the sale in the morning, and Billy Trout of the Tennessee Department of Revenue will be presenting in the afternoon on sales and use tax. Ressa will be working with Kimberly on an article about the Notify app that is offered to notify of changes, status updates affecting licensees to the public. And if the proposed rules are ready to be published, we can include those in the newsletter that will go out in June. We're currently working to identify our fiscal year 2015 venues and speakers at this time. Thank
Perfect.
you.
Thank you for that. Kimberly, are you you got everything done? You got anything else you want to add?
I have two little items.
All right.
I promise. Real quick, your final legislative update. Session closed the Thursday before Good Friday. And there was not any legislation that specifically affected the Auctioneer Commission this session, so.
About that deal you were looking at that came up.
I forgot what it was now.
Okay.
It was regarding the,
Packers and State
no, it wasn't Packers and Stock Cards. It was the selling of state property, correct?
That's right.
That,
We were
that,
gonna try
that
to get these
you were
licensed
looking,
auctioneers.
Oh, yeah, I don't know whatever happened.
right, and that didn't specifically affect the commission.
They passed the, privilege,
The
Privilege
professional
tax thing?
privilege tax, yes, sir. In a form that I have not seen yet.
yeah, because they can't double dip if you're already paying it as a,
There was something passed regarding.
$400 fee?
yeah.
Yeah.
The $400 fee. Again, we haven't seen the public chapter. That is one that's sort of an umbrella that affects some of our boards and commissions, but regulatory boards as a whole. And that, Mr. Hanson mentioned in his education update that we are going to be putting something in the newsletter regarding Notify. I believe everyone is signed up for that to get emails. And we'll send out an update regarding the rules once they are filed with the Secretary of State's office and publicly notice the meeting where you will have the hearing. The final thing is the NAA conference and the NALOA meeting in Louisville, Kentucky, July 8th through 12th of 2014. Historically, I believe the commission has voted to send representatives, and I would ask the chairman at this time if you would like to decide who you would like to send this.
Who's going to conference? You going? Howard, you?
I've never been to one in my life.
You
going?
I'll probably try to go to Louisville, yeah.
I plan on going if we have spots for two. Then maybe Bobby and I could go, and I know
Messed up last year.
Noola
I'm
wants
gonna go
me to run as president of that, and I
Oh,
don't
you
know
gonna run
about.
for president of NALA?
Yeah.
Cool.
But
President what?
National Auction License
But
Law.
I didn't want to put my name in the hat if I wasn't going to be there. So
Right.
It all is.
I know. If I could get a motion
Ed Woodley knows.
saying who the two that
Chairman,
the
if you take me,
commission,
I'll vote for you.
who the commission would like to send, and we will
Make
draft
that
all
a
of
motion,
the
Ron.
appropriate paperwork for your travel and.
Motion for you to speak of who you're gonna send, or I make a motion to send Jeff and Bobby.
there you go.
Second.
Made and second. All in favor, say aye.
Aye.
Thank you. Motion passes.
Thank you so much.
Is there any other new business, old business?
Yes, sir.
Go ahead.
I think that I read where Susan is leaving us.
I
And
heard
I'd
that
like-
too.
I'd like to commend her for all the hard work that she's done over the years and how much I appreciate you.
We're gonna miss you.
We're gonna miss you, and we may be coming over to get a health check. You don't know,
Well, thank
but
you.
we will miss you.
Well, I would add to that she's been great for me, and when I was transitioning on, she was very helpful, and it just has always been there, and always just whatever we needed, she was there, and we appreciate all the hard work and all the things that you've done. We will miss you. We hope that whoever we get to replace you is equally as good and as happy and enjoyable to work with. So I appreciate that very, very much.
Thank you.
That
I move with John.
we've been moved to adjourn, so we shall be adjourned.
You know Brad Woodley. Brad's big. I wouldn't say that. He's a great guy. He's a great guy. He's a character. Up in Arkansas. He's great.